Yes.
So the other two, the question then becomes, what do you do with them if you're with me? On the question of exclusive jurisdiction and this question of only in strictly necessary circumstances. The question is, it's a very difficult question. But my submission is, similarly, that the DA in Corruption Watch's applications should similarly be postponed sine die. Because it would be inappropriate to give any relief pending a constitutional court decision of the kind that we've gone through in circumstances when. But now they've got a question is, do they get interim relief pending the constitutional court application? Now I run into the same difficulty that I ran into in my opposition to food. Because if the constitutional court reject my exclusive jurisdiction argument, then they might be able to get relief pending Part B. Part B then is alive. So it would be inappropriate to dismiss the relief in that sense. I know that sounds mathematically jigsaw puzzle, but that's where. So we say all three applications, from our perspective, should be postponed sine die. Let the Constitutional Court deal with this question of the world of exclusive jurisdiction. Very sensitive world, a very difficult world to live in. Separation of powers, the red light that should be flashing before this court. Let them decide the Constitutional Court. And then, when the wash comes out, Fool can have a full go at its final relief, DA and Corruption Watch can have a full go, and then maybe final relief as well, maybe interim relief, they can decide then. So let me just conclude, I'll be very quick, to say on this point. We, in paragraph 2 of our heads, page 18, case numbers 18-6, we say, in opposing the relief sought, and we want to emphasize this, the African Transformation Movement makes no submission concerning the conduct of the Speaker, conduct of the National Assembly, the rights of Dr. Hlophe, and Umpuntu Isizwe, and I should add, any of the applicants. We make no submission. What we're here to do is to show the court, or demonstrate to the court, why the court should tread very carefully in granting any relief of the kind that's on the table today. That's why I'm here. It's not about the DA, Corruption Watch, Fool, or any of the other parties. It's about the rule of law. That's what this case is about. Now turn to the merits. We essentially align ourselves with the other respondents who are Thoko, Dr. Hlophe, and NK in this sense. We said in our affidavit, the ATM, that this case isn't about what one might feel is philosophically or can't remember the other word, let's call it politically interesting. It's about the law. It might be philosophically, it might have a feeling, a vibe, as the Constitutional Court wants to mention, that Dr. Hlophe shouldn't be there on the JSC. That's not what the case is about. The case is about, he is an MP. Now some people might not like that. Too bad to say. He is an MP, he's sworn in, and once you're an MP, you have that which all MPs have. Some are not better than others. There are 400 of them. Some are men, some are women. Some belong to some political parties with particular political bents, others belong to others. Some have got different pasts to the others. We know, we see. Some have been kicked out of one party, gone to another party. Some have been impeached as a judge, just one. But he's equal. He's equal to others qua MP, not a judge. That's finished. That career of his is over for now. He's an MP, he's a member of parliament. And the question is whether that member of parliament, despite his checkered history, such as it may be, disqualifies him from that which the other 399 members of parliament may be entitled to and may have the right to. And the answer is no. His past, whatever it may be, is in the past and remains as it was the day that he was sworn in as an MP. If there was an objection to his past, then that was the time to deal with it.
And if I'm understanding you well, your submission is that his past is irrelevant.
Well, his past
is irrelevant.
Irrelevant to his position sitting as an MP being designated by vote by the National Assembly.
Yes, then you are saying it's irrelevant to these proceedings.
In that sense, yes. His conduct is irrelevant.
That's your submission.
Yes. I don't want to make it in a blanket. I make that submission in the context of the relief that is being sought today.
Yes, but it must be in the if it's in context of the relief, it's in context of these proceedings.
Yes, no, I accept that. But let's say, for example, a party came along, and I'm just hypothetically making a hypothetical. Excuse me.
Hypothetical.
Thank you, my lady. It's long. Let's say a party came along and said he was impeached as a judge, therefore he has no right to be an MP. I could not in those...
No, nobody has argued that.
No, that's my point.
Yes.
But if that was the argument,
yes,
that would be different to what we have today. That ship is sailed. That's the point that I'm making. If somebody had argued that, then his past might be relevant to that case.
But that's not the argument.
Excuse me?
But that's not the argument.
That's not the argument, so therefore we don't have to worry about his past.
Yeah.
That's the point. His past isn't irrelevant in the broader scheme of the world, but it's irrelevant because he's a member of parliament and he's being designated qua member of parliament, it becomes irrelevant in that context. If there was some other case about what he could or couldn't do, whether he could be a member of parliament, of course his past might be relevant. Depends what the challenge is. This challenge is the challenge to the National Assembly designation. And it's a vote. And the National Assembly might have been unwise, they might have been wise, they might have been for good reason or bad reason. The principle is that's what the National Assembly chose. If that happens, the court must see those red lights flashing. Should we intervene, the National Assembly, who does what we as a court think is a terrible thing. Red light. That's the argument. And we explain it in our heads, and we don't want to get involved in what he did or didn't do, what the speaker did or didn't do. And we submit that the speaker gave a very useful and we think entirely appropriate explanatory effort of explaining what happened. There was a vote. And this court shouldn't intervene. We submit in vote. Then the court would have to find, and again it's a pleadings question, the court would have to find the vote was irrational. It's a vote. How do you find that a vote's irrational? You might find that somebody does something, the president calls his friends in and says, who should be the for? That might be irrational. Or the Similani proposition, where the president went to Similani and the court found he didn't consider the past. This is a vote. We don't know what's at the head of those 400 people. Some voted against, some voted for. How can 400 people come to an irrational decision in that sense?